Thank you for attending our webinar today. My name is Nate Krampe. I am the Vice President and Certified Financial Planner here at Summit Investment Advisors. Now, before we get started, I really want to share with you some areas of expertise that we focus on here at Summit. If you pull up our website, summitinvest.com, you will actually see the three areas that we have as expertise here. The first one is financial planning. And what that says is, it goes, where are you today? That's what we look at. We figure out where you want to be in the future, and we help fill in any gaps in between. Now, there are many ways to do this. Wealth preservation, wealth enhancement, and part of that comes into then everything related to the investment management side of things, making sure we have the correct investments to meet those goals that you have as well. That's our second area of expertise. Now, the last area of expertise that we're going to focus today's webinar on is the estate planning. Now, this is where we take a look at all the different details of what we call wealth transfer. And to do that, we're going to have a special guest, Cory Wessman, today to look into all the different details of estate planning. Now, Cory, he has obtained his undergraduate degree from Wheaton College. He has a master's degree from Iowa State University. He's attended the University of St. Thomas School of Law, and he practices exclusively in the areas of estate planning and trust and estate administration. He's a very, very good, competent attorney that we use quite often for bouncing ideas off of, as well as to put together some of our estate planning documents. Please welcome Cory Wessman. Cory.
Well, thank you, Nathan, for that kind introduction. I really appreciate the opportunity to speak to everyone today by this webinar. I hope that this is an informative presentation today. Perhaps you are joining us over the computer over your lunch break, so hopefully this will be a good use of your time during your lunch break at work or at home. I've really been honored to work with Summit, Nate, Nathan, and Sean and the team here. Our firm does estate planning work. We're just down the road off 35W, south of 35W in northeast Minneapolis, and we're honored to work with a number of Summit clients over the last few years. The first slide here on our deck of slides here is one that I often refer to because in our practice we are perhaps quite rightly accused of making things more complicated than they need to be. During our presentation today, we're going to try to keep things simple, look at things from 20,000 feet, so to speak. This slide says, on the bottom, the caption says, "To my loyal estate planning attorney, I leave my children a complicated series of trusts that will generate huge legal fees." Unlike the caption, estate planning does not need to be overly complicated or sophisticated, but we do need to address certain basics. So during today's webinar, I want to cover a couple of important basics in terms of estate planning. We're going to talk about estate planning basics. We're going to talk about taxes. If you've got a caffeinated beverage for lunch, you might want to reach for it by this point in time, just to stay awake, hopefully. Caffeinated beverages are good with taxes. And then finally, we'll talk about a couple of tax and charitable planning strategies. So real basic estate planning is really about several sets of key decisions. Who has the authority to make decisions for you? Who has decision-making authority in the event that you're alive but not able, by reason of your health, to make your own decisions? So we would say during a period of mental incapacity, who has the authority to make decisions? And then following your death, as we'll discuss here in a moment, who has the authority to follow through with your direction that you've given in a will or trust? Who are the recipients, beneficiaries? That is to say, who is going to receive whatever's left, whether it's the stuff in your house or your investment accounts or retirement accounts. Who are the beneficiaries? And then when do they receive those assets? There are two different important disability documents. One is what I call a power of attorney, or what's generally called a power of attorney, and that's really important for a lot of our clients and their families when they're alive but not able, by reason of their health, to make their own decisions. So a power of attorney is generally somebody that you know and trust. Doesn't have to be an attorney, fortunately. Can be a spouse or an adult child, somebody to make financial and legal decisions for you. Likewise, a healthcare directive allows you to designate somebody to make healthcare decisions for you if you're not able, in the opinion of your medical care provider, to make healthcare decisions. So a power of attorney and a healthcare directive are documents that we recommend for everybody 18 years of age or older. So when we're talking about estate planning basics, if you don't already have those in place, those would be key documents to make sure that your spouse, perhaps your adult child, a sibling, somebody has the legal authority to make decisions on your behalf. One of the common questions that comes up in our legal practice relates to how assets pass at death. So what I want to talk about next is just a real basic description of how assets pass at death. Assets can transfer at your passing through a number of different ways. The most commonly thought of or referred to, especially for my married clients, is when spouses jointly own assets. So if my spouse and I jointly own our home or a bank account, one of the attributes of that ownership structure is that at the first death between us, the surviving spouse automatically becomes the new owner of those assets. And that is regardless of what will or trust or any other legal documents we have in place. So I want to address a couple of sources of confusion that come up often with new clients, and one of them is, how do co-owned assets pass? And the short answer is immediately and directly to the surviving co-owner. Another type of ownership arrangement is what's called a beneficiary designation, and this is most common with retirement accounts or life insurance policies. If I have one of those two types of assets, excuse me, then those assets would pass at my death to the individual or charity or individuals that are listed with the retirement account administrator or the life insurance company. That is, again, a type of legal arrangement that does not require another type of legal document such as a will or trust. So it's very common for our clients to have a little bit of confusion, at least before we've had the opportunity to speak with them, a little bit of confusion about having a beneficiary designation in place and whether a will or a trust supersedes that. And generally speaking, the beneficiary designation you have in place is what's legally binding in the event of your death. Finally, on this page, if you're following along on this slide, a third and final way of holding assets is through what's called a revocable trust. A revocable trust. And I'll speak a little bit more in greater detail here in a moment about a revocable trust. But for now, I just want to state that it's a type of way, or it's a method by which you can transfer assets to other friends or family members or charities through what's called a non-probate, or just having a method in place so that assets pass outside of any court system. So the three that I've just mentioned, co-ownership, beneficiary designation, or revocable trust, these are ways that a lot of our clients create a plan to transfer assets outside of what's called probate. Anything that's not listed in one of these three types becomes what's called a probate asset. And a probate asset is just any asset that passes through the probate court process. Probate is a branch of the Minnesota court system that has its goal the proper legal transfer of assets that are in a deceased individual's name. Some clients come to us have had a bad experience in probate previously, and so they'll sit down with us and want to do what they can to avoid probate proceedings. Probate, again, doesn't mean that the state of Minnesota receives a greater percentage of your assets through tax revenue or that the money is somehow lost to the state. It just means that there is a court oversight for the transfer of those assets. All that being said, in order to ease the administrative burden on the assets that you own at your death, certainly any one of these three non-probate forms of transfer are preferable over probate means. If you have a will, then those remaining assets that go through probate would be directed by your will. If you don't have a will, the state of Minnesota creates what's called a rule of intestacy, which just means that it assumes you wanted to have assets go in a certain method. So if you're married, then everything would go to your spouse, generally speaking. If you have kids and no surviving spouse, it would go to your children. But generally speaking, we want to sit down with folks who don't yet have a will and make sure that their assets do pass to their designated beneficiaries. Within any estate plan, we want to make sure that we're covering who the key individuals are and who has the key decision-making authority following your death. The one that most people have heard of, or many people have heard of, as it relates to the key decisions under an estate plan would be what's called an executor. And an executor is an individual or a bank or another professional person who takes on the task of following through with what your will says. So if I'm named as an executor for a family member and that family member passes away, not until then, but only following death, then the executor, I as the executor, have to follow through with the direction in the will. So I'm giving assets to those named beneficiaries under the will. We now call that a personal representative under Minnesota law. If our clients have children under age 18, it is critical that they designate a guardian, somebody who's a stand-in parent in the event that the natural parents, or at least the legal parents of the young children, both pass away. Finally, a trustee is an individual or a bank or another professional institution that's responsible for overseeing the financial distributions and financial investment matters with any assets that go to a trust for a beneficiary. Since I'm giving this webinar today, I get to share at least one family picture. Those are my three living children there at the bottom. The picture to the left of the little boy who decided to do some home improvement projects in his home is not my child, but between the two pictures, I think you probably know where I'm going with this, and that is many of us are in a situation where our beneficiaries are not in a position to be able to individually manage their own assets. Now, in my case, it's clear that it's generally just by reason of age, but for many of our clients who have adult children, they've discussed or they've demonstrated that the adult children need some help in managing the inheritance. So one of the things that I wanted to mention today, and just give you some food for thought over your lunch hour here, is the use of a testamentary trust. A testamentary trust allows you as the trust creator, sometimes known as the settlor or the trustor, to name a trustee to manage the assets. So in my case, we name a brother-in-law to serve as a trustee who would manage assets if both my wife and I passed away. And that trustee would invest the assets with Summit or a similar institution and make distributions for the benefit of a beneficiary. So in some respects here, we're using an intermediary called a trustee to follow through with our wishes. So the benefit of a testamentary trust is that you can create a legal structure to really minimize the risk that money is used improperly or poorly, or that would have a negative tax effect. The use of a testamentary trust is different than the use of a revocable trust. So a testamentary trust would, in my case, apply only once both my wife and I have passed away. And in that event, a trustee would manage the assets for the benefit of our children. Another type of trust that I want to carefully distinguish from a testamentary trust is a revocable trust. And this type of trust I generally think of as like a moving truck. And the idea with a revocable trust is that you're going to create a structure to hold your assets during your lifetime. So the idea is that you continue to possess your assets, but you're making an arrangement through a vehicle called a revocable trust to have assets titled or held in such a way so that it's easy to move the assets down to the next generation. So the vehicle here, being the revocable trust, is not the beneficiary in itself. It's just the way that you title assets during your lifetime to avoid probate proceedings. You'll recall a few slides ago, I discussed the use of a revocable trust as a means to avoid probate. So many of our clients use a revocable trust to accomplish exactly that. I was just in Arizona a few weeks ago, meeting with some clients in Arizona. I've got an Arizona law license because many of our clients here in Minnesota have established residency in Arizona. And so one of the benefits of a revocable trust is the ability to avoid probate proceedings in multiple states. So if you have real estate, you would want to, or at least consider, the use of a revocable trust so that you avoid probate. And in my case, the folks that I know in Arizona have got properties in each of these states, that is Minnesota and Arizona, and so by creating a revocable trust, we can avoid probate in multiple states. The benefit of a revocable trust, again, is mainly avoidance of probate. Relatedly, it protects your privacy. That is to say, because there's no court procedure or hearing, there's no public disclosure over the nature and extent of your assets in the event of your death. The one downside of a revocable trust is that it does require a little bit of ongoing care and feeding, so to speak. There's no additional legal cost per se on an ongoing basis of a revocable trust. It's just that if you do transfer, so you buy a new home or you open up a new bank account, it is important that the revocable trust be considered to be the owner of those accounts. Now, this might be a time to reach for that cup of coffee or that Diet Coke, and let me jump into taxes. just very generally, I like to think of when I talk about taxes as your estate plan comprising 3 different buckets. And that is to say, you can give assets to friends or family, bucket 1, to the government, bucket 2, or charity, bucket 3. Not surprisingly, to the extent that you give assets to family and friends, that is individuals, or even in my case a trust for my kids, then we're slightly increasing the amount that goes into bucket 2, government. To the extent that you give to charity, you are cutting out Uncle Sam and the state of Minnesota. So that's one thing to think about as you think about your own estate plan, whether by reason of lifetime gifts or gifts at death, that assets going to charity are going to cut out the government. In terms of taxes, there might be 2 things just to write down in terms of your notes today, the take-home lessons from today's webinar about taxes. Is that there are 2 layers, potentially 2 layers of taxes. And these are, very briefly, income taxes. One is income taxes, and the second is estate, or sometimes referred to as death or inheritance taxes. So again, that's income taxes and estate taxes. In general, the good news is that your beneficiaries do not pay income taxes on a gift or an inheritance. That's the general rule, is that if you direct that your children or your nieces and nephews or your neighbor is to receive X amount following your death, those beneficiaries do not pay any income taxes, and they should not even report that on their personal income tax return. The large exception, increasingly large exception, with a lot of us who have tax-deferred retirement accounts, is just those types of accounts. The idea here is that because we as the account owner have not paid income taxes on those accounts during our lifetime, the IRS, the state of Minnesota, will tax those remaining retirement accounts. But, and this is something that Nathan and Sean and others here at Summit can help you with, but only to the extent that the money is taken out of those inherited retirement accounts following the death. So, stated differently, retirement accounts are subject to income taxes following your death, but only when your children or nieces and nephews pull the assets out of the tax-deferred accounts. The other layer of taxes is estate taxes. Here, this is a one-time only tax that's levied literally by or as of 9 months from the date of your death. When we calculate an estate tax, we include everything of value, whether it's life insurance, death benefit, home value, investment value, retirement accounts. All of those assets are lumped in for purposes of determining what a possible estate tax would be. There are a couple of key deductions that you should be aware of when it comes to determining an estate tax. If I die, then regardless of whether I'm wealthy or not, because my spouse would presumably survive me, and likewise with my wife, for me, assets that are passing to each other would pass free of any estate taxes whatsoever, and that's through what's called the unlimited marital deduction. Similarly, if I give everything to charity at death, then all of those assets pass free of estate taxes as well. You recall my 3 buckets approach, and this is the application of that to the extent that you give assets to charity, those assets would not trigger any estate taxes at death. And of course, expenses, things like mortgages, all of those would not, the payment of those would be deductions that would not go towards an estate tax liability. finally, the reason why most Minnesotans and Americans don't pay an estate tax or a death tax is because of what are called the exemption amounts. So if I have assets below $1.8 million and I die, then even if my spouse didn't survive me and we couldn't make use of that unlimited marital deduction, if assets are just going to the trust for our kids, then there would be no state estate tax. The federal estate tax is only triggered once assets are in excess of $5.5 million. Now, there's a significant difference on the rate of the assets or the tax in excess of those exemption amounts, but nonetheless, the federal estate tax exemption is high, such that most 99% of Americans will not pay a federal estate tax at death. There is what's called a gift tax. Now, this is one of the more common sources of confusion in our practice that relates to gift taxes. And I think it's relevant to just to pause here and discuss this, because almost always folks are not going to be paying a gift tax, but it's helpful to walk through the gift tax to understand the history. You can give an unlimited amount of assets to your spouse, free of any gift taxes, and you can give up to $5.5 million to your family members free of what's called a federal gift tax. So the background with the gift tax was that a number of years ago, when the federal government instituted the estate tax, this savvy Americans realized that in order to avoid estate tax, they could just make lifetime gifts. So in order to stop that and to retain the taxable revenue of those wealthy families, Congress instituted the gift tax, just saying that you can't give more than $5.5 million free of, or without, I should say, 5.5 without triggering a federal gift tax. Now, the source of confusion comes in with regard to what's called the annual exclusion gift. This is the amount that you can give on an annual basis without even reporting the gift to the IRS. And the rule is, as long as you give $14,000 per year or below per person, you don't even need to file any tax returns. So by way of example, if I gave $10,000 to each of my 3 kids, I do not need to report that to the IRS. That's not reported on any tax returns, and that's what's considered the annual exclusion for that particular year. If I gave $15,000 per child, then I would file what's called a gift tax return to show that I used my $14,000 annual exclusion, but $1,000 more than that, I would file a gift tax return to just show that $1,000, the balance on that gift, goes towards my $5.5 million lifetime exemption. So there's no tax there, I just have to report it. So you see that it's very unlikely that most of our clients run into a federal gift tax problem. That $14,000 is just the de minimis rule that says you don't need to even file anything if you give below that amount. When President Trump was elected last November, we looked at his tax proposals, and I thought it might be relevant to share a few of these with you today. He has proposed to eliminate the estate tax as well as the alternative minimum tax, and that's the tax that high income earners pay at certain thresholds. The proposal calls for an increase in the standard deduction, and that would have an impact for those Americans who itemize or previously itemized, because it may now make sense to take a standard deduction rather than an itemized deduction. And then there are new proposed income tax rates. But for purposes of our summary, it is relevant, our discussion here today, that he is proposing to do away with the federal estate tax. The state level, I want to point out a couple of issues. There is no state gift tax. So what I just described related to the federal gift tax is not really relevant to the state of Minnesota because there is no such thing as a state gift tax. So theoretically, you can give an unlimited amount of assets to friends or family and not pay a state level estate tax. There is, however, what is called a 3-year rule for Minnesota estate taxes. So here, if I make a gift above $14,000 in a particular year, and then I die within 3 years of that gift, the value of that gift will be treated as if I had owned it at the time of my death, so that the state of Minnesota will impose an estate tax on it at that time. Now, of course, if I make a gift and I'm not going to have an estate tax anyway, what difference does it make? So this rule only applies to those clients of ours who will have a Minnesota estate tax at the time of their death, and they had made a gift within 3 years of their death. Finally, and this is perhaps most important as it relates to Minnesota estate taxes, the $5.5 million federal estate tax exemption is automatically ported, what's called ported, to the surviving spouse at the first death. So if I pass away and my spouse survives, my spouse can automatically use my $5.5 million federal estate tax and gift tax exemption, so that when combined with hers, she would have the right to give away $11 million. Okay, that's the federal rule on the what's called the portability right of this exemption. There's nothing really that needs to be done other than filing some tax returns following the first death to make use of both of your exemptions. That's not the case at the state level. So the amount that I mentioned earlier of $1.8 million per person must be, we have to set up a certain structure for a spouse in order to make use of both the husband and wife's $1.8 million Minnesota state tax exemption. All of this to say is that if you have assets in excess of $1.8 million and you have not considered under your estate plan how to properly utilize each of your exemptions, then you should talk to Sean or Nathan or myself about how to properly do that. Related to that, here's yet another cartoon in this regard. You'll see the gentleman saying it was painted by a tax accountant shortly after going insane. So that may be what you're thinking right now. The abstract art doesn't make a lot of sense. But I think that the main point of what we just described is that for a lot of our clients, they don't need to worry about estate taxes. If you are at or above those thresholds, we should at least have conversations about whether the planning that you have in place is appropriate. I want to just end our webinar today with two tax planning strategies that we've been able to implement to good effect over the last few years. So I'm just going to close our time here today with two tax planning strategies that have been successful. Of course, there's many more than this, but these are tax planning strategies that seem to come up from time to time. The first is only relevant if you, based on your unique financial situation, would potentially pay estate taxes, specifically Minnesota estate taxes. As I previously described, the exemption amount for this year is $1.8 million. So if you have assets in excess of $1.8 million and you pass away, giving assets to friends or family members, those assets would trigger Minnesota estate taxes. What's the best way to minimize that? Well, it is to make gifts to friends or family so that at the time of your death, you're not considered to be the owner of those assets. The Minnesota rule, or the rule specific to Minnesota estate taxes, says that that's all well and fine unless you made a gift, a substantial gift, within 3 years of your death. And what I mean by a substantial gift is a gift over that $14,000 amount. If you make that gift and then you die within 3 years, again, there's an estate tax levied on those, not only the rest of your assets, but the amount of that gift. So the basic strategy here is, as you might gather, is to make gifts as soon as you can. So the little illustration here just demonstrates that if you give gifts, if you can give gifts before the 3-year period that ends on the date of your death, or in other words, more than 3 years before you die, then there's no estate tax on that gift that you gave. So we always say, do your giving while you're living so you're knowing where it's going. In other words, enjoy the benefit of seeing your kids, grandkids, nieces and nephews benefit from the assets while you're alive, and you can see them enjoy and benefit from it. The second strategy is just to consider how you go about giving gifts to charity. So this would be a tool, a strategy that's only relevant if you want to give a substantial amount to favorite charities. If you're going to give amounts to charities, then it does matter, it can matter, which of your remaining assets go to that charity. If you'll recall a few minutes ago, we talked about the income tax benefit of just giving assets to your friends and family members, namely that the general rule is that your friends and family members can receive your assets free of any income taxes. The large exception to that general rule is that any tax-deferred retirement accounts do trigger income taxes when you pass away. So, all other things being equal, your friends and family members would prefer to receive $500,000 worth of, say, home equity or investments rather than $500,000 in retirement assets, because once they receive that $500,000 in retirement account assets, they can only get at that money if they pull it out, and when they pull it out, they pay income taxes. So, all other things being equal, when we look at assets, we would like to try to pick and choose how your non-charitable beneficiaries receive assets, namely not receiving retirement accounts. In contrast, if you have a favorite charity, it is a very powerful strategy to say, if my favorite charity is, for example, Presbyterian Homes or United Way or American Cancer Society, I'm going to designate a certain percentage of my remaining retirement accounts to that charity, and that charity can receive that entire percentage of assets. So if it's a $500,000 retirement account and I give them 20%, they receive that entire $100,000 amount free of any income taxes. So it is a powerful planning strategy. The strategy that we implement for our clients in a scenario like this calls for the distribution of the remaining retirement account assets to the favorite charity and naming the friends or family members as the recipients of the other assets under their will or trust. So it's as if we are allocating a greater percentage of remaining retirement account assets to those charities and essentially reducing the amount of money that the charities receive from the other remaining assets. As long as we can carefully review this on an ongoing basis, sometimes we say we're babysitting the beneficiary designation. In other words, carefully reviewing what the value of the retirement account is versus or in comparison to the other assets. It's a powerful strategy for minimizing taxes. Again, if you're in this camp, if this all is similar to your objectives in terms of wanting to make provision for both charity and children, then I would strongly recommend you give us a call and review your situation so that we could possibly implement it. I've really enjoyed working with Sean and Nathan and the team at Summit. We are working with many different Minnesota-based families on their situation, whether you have significant or relatively insignificant amount of assets. We enjoy working with a wide demographic of clients, married, single, in fact, in some cases, multiple generations. Our general rule of thumb is that if you haven't reviewed your estate plan in the last 3 to 5 years, it might be worthwhile to sit down with us. I have my email address here and my associate Ryan Damoff's email address here on the last slide. Please give me or Sean or Nathan a call or an email with any questions. Our role, as we see it, is to come alongside your existing advisory team to implement a plan that makes sense for you. So again, we welcome questions. I hope this has been somewhat of a beneficial and educational webinar. But again, don't hesitate to contact us. Thank you, and just have a great day.